I'm Caroline, and I'm a senior legal counsel in the legal team in the credit branch. And today I'm going to talk to you about repayment difficulties and other similar issues. We also shared the same information with lenders at our lender seminars earlier this month. Repayment difficulties are all covered extensively in Chapter 12 of the Responsible Lending Code. What I'm going to do today is to summarise some of the main parts of that chapter and give you some examples of how we see Chapter 12 working in practice. I highly recommend you familiarise yourself with the code. Chapter 12 was significantly amended and the new version has been in place since the 1st of February this year. It deserves a good read as there's lots of helpful information in there. This chapter would be very useful for borrower advocates helping people in debt. It sets out how lenders should be working with borrowers who are having difficulty paying their loans that might not be caused by an unforeseen event. Just a quick reminder about the code. It's not binding, meaning lenders don't have to comply with it, but if they do follow the code, then this is evidence of compliance with the responsible lending obligations. And Chapter 12 mainly provides guidance for lenders on how to comply with Section 9C(3)(d). That's the part about treating borrowers reasonably and ethically. So when the borrower breaches their agreement or is likely to, and when the borrower makes a hardship application. So I'm going to talk about 4 key aspects of Chapter 12 that lenders should be doing and what to expect from them when you are advocating for your client. Firstly, lender staff training. We talk to lenders about training their staff that deal with payment problems and ensuring that they have the right policies and procedures to work with borrowers who are facing repayment difficulties. Secondly, what lenders should be asking borrowers who say they've suffered substantial hardship. Thirdly, the types of repayment relief and information they should give to borrowers. And lastly, some things that lenders cannot do. So the first topic, policies, procedures, and staff training. To start with, lenders should have policies and procedures in place, and staff should be trained on these 2 topics: how to identify repayment difficulties and how to deal with borrowers who have repayment difficulties. So firstly, staff should be trained to recognise repayment difficulties. For example, employees should recognise signs of repayment difficulty, such as if the borrower calls up and explains that they cannot make their repayment because they've lost their job, or there's been a pattern of missed payments, or request to change payment dates or to refinance. Secondly, staff should be trained on the company's policies on what to do when they realise a borrower has repayment difficulties or who to ask for assistance. Staff should encourage the borrower to engage about repayment difficulties, explain that there are processes available, and clearly communicate the company's willingness to engage with the borrower. There is information that lenders should provide to borrowers, inquiries that they could make of borrowers, and we'll talk about these next. So if your client has entered into a payment arrangement due to financial difficulties, you would expect What would you expect that lender to do around ongoing marketing or promotion of new credit for that person? So you would expect them to suspend it. And this is covered at point 12.36 of the code. If your client is still getting offers of further credit when they are in a payment arrangement due to financial difficulties, you can ask the lender to suspend those offers using this section, and you should tell us too. So second topic. What lenders should ask about. Where lenders become aware that a borrower is having repayment difficulties, they should try to establish, firstly, whether repayment relief is appropriate for the borrower. Secondly, what repayment relief may be appropriate given the borrower's particular circumstances. And lastly, whether the borrower is eligible for the statutory hardship process. If the lender recognises that a borrower has repayment difficulties, they should ask questions like, what's the reason for the repayment difficulties? What are the current or expected changes to income or expenses? How much can the borrower afford in the current circumstances? How long are they going to be impacted for? And are they eligible to make a claim under a repayment waiver or a claim under an insurance policy? And what steps the borrower is taking to address these repayment difficulties? So when the borrower has a repayment difficulty, should the lender try and defer all payments for a long period of time, such as putting them on a payment holiday? And this is a question where it really depends, and the lender should be working with the borrower to understand their situation and work out what is appropriate relief in those particular circumstances. So, for example, if the borrower is off work and unable to make repayments for 2 weeks, offering them a 3-month payment deferral may not be appropriate, as the borrower will incur more interest and the length of the loan would be extended by a period probably longer than necessary to address the specific hardship in that situation. So now we're going to talk about what lenders should do when they've established that there are repayment difficulties. Generally, there are 3 main types of payment relief: relief without variation, varying the contract using the statutory hardship process, and lastly, other variations. So relief without variation to the contract. This is where the lender provides some sort of relief without having to officially vary the contract. For example, they could waive the late payment fee or a default interest. Varying the contract using the statutory hardship process. If a borrower is in a situation of unforeseen hardship, such as something that is event-related, lenders should encourage them to apply for unforeseen hardship relief. This generally happens if the borrower loses their employment, goes through a relationship breakdown, or suffers an illness or a death in the family. The application must be in writing, but it could be electronic, and it does not require the signature of the borrower. If the lender agrees to make a change that will alter the contract, like reducing payments or extending the term of the contract, it's very important that they give the borrower variation disclosure. The last option is other variations to the contract. So even if the borrower does not meet the unforeseen hardship criteria, they should still consider agreeing to a repayment plan, such as reducing the payments for a particular period of time, or reducing or cancelling default interest. Lenders should take the time to explain the different options and the consequences to the borrower. For example, should they offer to fully defer payments for 3 months or allow the borrower to make partial payments if further costs will be incurred as a result? And the lender should be making this clear. Lenders have legal responsibilities to borrowers in all subsequent dealings, so in this case, they have to assist the borrower to make an informed decision. So do lenders have to agree to repayment arrangements for financial difficulties? And the answer to this is no, they don't. But if they decline it, they must provide a reason why. The borrower or you as their advocate can make a complaint to the lender if you are not satisfied with the answer. You can also escalate it to the lender's dispute scheme if you can't come to a suitable arrangement with the lender. Do keep in mind that any arrangement does have to be fair to both the borrower and the lender. So if you are advocating for a new client and you want the lender to suspend interest payments or default fees while you work on a solution, does the lender have to comply with this request? And the answer again is no, they don't, but it doesn't hurt to ask. Keep in mind that asking the lender to suspend the interest payments may require a contract variation, as it's likely to affect the amount the borrower pays. If so, the lender can charge a reasonable fee for that variation to cover the costs involved. So moving on to the last topic, I want to cover some practices that are prohibited by the Responsible Lending Code. So these are things that lenders must not do. A lot of these relate to the use of direct debits. So lenders cannot hold multiple direct debit forms, and when a borrower cancels one, they cannot lodge another one without a borrower's consent. Lenders cannot tell a borrower or imply that they cannot cancel a direct debit. Lenders cannot continue to receive money from a borrower by direct debit after they have realised the loan has been fully repaid. Lenders should have systems in place to identify when such payments are being received on accounts that have been fully paid. This would be the case for attachment orders too. Lenders cannot let a borrower exceed their credit limit and charge a fee without giving the borrower information that explains that they may be able to exceed the limit. Lenders cannot request or arrange for the borrower to have their loan repayments automatically deducted from their benefit or wages where a borrower is having repayment difficulties and is engaging with lenders, unless lenders have reasonable grounds to believe that the borrower would be able to discharge their repayment obligations while also meeting necessities and other financial commitments. Lenders cannot take a new guarantee or vary an existing guarantee after a borrower has defaulted without informing the guarantor that the guarantee or the variation is necessary because of the default. And lenders cannot require a borrower to make an application for a KiwiSaver hardship withdrawal as a prerequisite for a hardship application. And lastly, lenders cannot contact or communicate with anyone other than the borrower or an authorised representative beyond the minimum extent necessary to reach the borrower. If lenders hold an assignment of wages and intend to forward this to the borrower's employer, they should inform the borrower of any rights the borrower has to withdraw the written consent to the deductions and of the intent to contact the employer. This gives the borrower an opportunity to explain the situation to the employer. And when a borrower is facing repayment difficulties, lenders should take into account the borrower's preferred means of repaying the debt. So the key takeaways from today. Everything that I've spoken about today is covered in more detail in Chapter 12 of the Responsible Lending Code. And the key things that I want you to remember about what you should expect from lenders around repayment difficulties from today's session are, firstly, lenders should have policies and procedures on how to deal with borrowers who face repayment difficulties, and they should train their staff on these. This is also part of their due diligence obligations to ensure they have policies and procedures in place to comply with the CCCF Act. Secondly, lenders should be working constructively with borrowers and their representatives to try and establish what repayment relief is appropriate and for how long it should be in place. Thirdly, there are different types of payment relief that could be provided to borrowers depending on their situation, and lenders should be helping borrowers understand what those different options mean for them in the short and the long term. And lastly, the Responsible Lending Code prohibits some specific practices in relation to dealing with borrowers who are facing repayment difficulties. If you notice these things happening, you can make a complaint to the lender, escalate it to the lender's dispute scheme if you can't achieve a suitable outcome with the lender, and definitely notify the Commission about it. At the very least, if you think their conduct needs improvement, we can write to lenders effectively, putting them on notice, and we'll expect to see a change. Thank you. Paul, back to you.
I'll just get you